Excuse me, Susan. This is Allison from the recording secretary. I cannot hear any audio from the room. Susan? Susan, this is Allison. I am not getting any audio.
Hello? I can't hear you.
Hi. This is Allison, the recording secretary. I did not get where the Mr. Versilla called the meeting to order or the pledge.
Well, I'm not saying the pledge.
What'd you say?
She said she couldn't hear anything.
She can't hear.
Can you hear me now?
I can hear you now, sir, but I did not get the pledge or when you called the meeting to order, sir.
Can you hear me now?
Can you hear it now,
I can hear
Allison?
you now.
Hello?
Yes, I can hear you now.
Did she say yes?
She said she heard it.
Yes,
Okay.
I can hear you.
All right, welcome to the Hillsborough County Code Enforcement Special Magistrate hearing. When addressing the magistrate, please state your name, address, and speak clearly in your microphone. If you are planning to speak during this hearing, you must sign the speakers list located at the front door so your case may be called. Any person who decides to appeal the decision of Code Enforcement Special Magistrate will need a record of the proceedings. The record is comprised of the testimony and evidence on which an appeal is based. It is your responsibility to ensure that the verbatim record of the proceedings is made. By law, you have 30 days of my order to appeal the decision to the circuit court. Presentations by the county, respondents, and opposition must be kept to a maximum of 10 minutes each. The basic process for this hearing is as follows. Ms. Myers will conduct the oath of witness. Your case will be announced. Staff will present the evidence in your case. You will be allowed to rebut the evidence and explain what has occurred. I will close the hearing and announce a decision. I may ask questions and allow other witness testimony if necessary. Depending on my order, the county staff may later have to conduct an inspection to see if you've complied. For false alarm and water resource cases, you have not complied by paying the past due burglary false alarm fine and water resource penalty fine within a time order. You will receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against your property. If the staff believes that you have not complied, you will receive a notice in the mail. By law, you have 10 days to contest that notice, otherwise it will be considered correct and a lien may be filed against your property. If you have any questions, these rules and outlines are outlined by Hillsborough County Code and Ordinance and Laws, Chapter 14, Article 2, Section 14. Before we begin, including myself, please silence all cell phones. Okay. All right, Ms. Myers will conduct the oath of witness.
County staff, please stand and raise your right hand to take the oath of witness. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. First case is on page 4 of your agenda under burglar alarm ordinance cases, number 5, case number BA 129952. The owner is Fulfilling God's Purpose Church Incorporated, and the violator is Life Point Church, location 501 South Kingsway Road. We have service and we have a representative here to speak. If you're here for this case, please come up to the podium. Hello, sir. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, yes, ma'am.
And state your name and address.
Hey, Xavier Mitchell, 501 South Kingsway. My address or the church's?
The church is fine. If
501 South Kingsway Road, Seffner, Florida, 33584.
And are you a representative for the church?
Yes.
Okay, thank you.
Tina Burney, Compliance Communities and Conservation, case BA 129952, data false alarm 8/25/22, 10/4/22, amount due $175.
Okay,
I tried to pay it online, but I couldn't. Yeah, I went to the address that's on here and I couldn't get anything pulled up to pay it.
So you want to pay it? You're not
Yeah,
really,
just to get rid of it. And,
okay.
did you bring your checkbook?
I got a debit card.
You have to do that online. You said you were having trouble
Yeah, see,
doing that?
yeah, they give you this long address and I typed in everything they gave me and nothing
Oh,
pulled up on the second page right here. And I've been trying to do this since I got this notice about 4 days ago. So I said I was just gonna show up and not, not disregard it.
Okay,
Like,
okay.
is it a place I can go to pay it instead
think
of trying to do it
Tina's
online?
gonna-
No, so if you just go to the code enforcement website, there's a link on there that'll take you to it instead of that long one that's in the letter that you received.
So,
It's hcflgov.net/code.
My phone's off.
okay.
Have a pen?
Tina, you want to go ahead and do this case just for the record so we can get an order?
Sure.
Okay.
Okay. I rule in the case of BA. Okay.
Are you wanting to pull the case so he can go pay it?
No, just do an order and then if he's
Ju-
gonna
okay,
pay it, I'll just
do you
apply
want?
it.
Okay, you're not going to do your part then.
I already read it.
Oh. Go ahead. I'm sorry. Go ahead.
Okay, I got boss man here. Boss lady. I rule in the case BA 129952 that based on the evidence presented, the violator has failed to pay the false alarm penalty fine imposed by County Ordinance 4-16. I grant the violator 10 days to pay the fine imposed in order that the payment be made by that date. A fine of $100 per day will be assessed. Okay, so you got 10 days. And if you want, can you give them an address or whatnot to? Was that skip or what? I'm not used to these cases. Okay, next case.
Okay, turn over to page 10 under water ordinance cases, number 21, case number, that's page 10, number 21. Case number WR 2202677. The owner is Dorothy Smith, 10623 Scenic Hollow Drive. We have service and Ms. Smith is here.
Yes, ma'am.
Hello, raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And state your name and address. Yeah.
My name is Dorothy Smith. I live at 10623 Scenic Hollow Drive, Riverview, Florida, 33578.
Thank you.
I got this.
Hang on.
David Kanzler, Hillsborough County Code Enforcement, on case WR 2202677. On Tuesday, the 8th of November 22 at 07:03, Officer Baker arrived at 10623 Scenic Hollow Drive to observe the sprinkler system in the area of the front yard on the right side of the driveway activated. This is in violation of the county watering ordinance for watering on non-watering hours. The location is south of the Alafaya River. This is the second offense for this location. The assigned watering days are Tuesdays only, but it was the right day, but the wrong time. Watering hours are from 8:30 a.m. to 12 noon or 6 p.m. to 11:59 p.m. The notice of violation was issued on the 2nd of December 22. It was in default on the 4th of January 23. The notice of hearing was posted on the 29th of March 23. For history on this property, there was a warning given in November of 22. The fine's $100.
Okay, now it's your turn.
Okay, I just came from overseas. I was in the Middle East during the time frame with the Afghanistan shutting down. I had somebody else watching my house. I did not know about the time frames. When I finally did come back to the States, I did not know about the time frames. Once I ended up going on ahead and started talking to my friends about this memo that was put on my door, that's when they told me maybe my watering days were off, or if it was the time frame. So I had two individuals make sure they came to my house to check to see what I was doing wrong, because it was not intentional. I just did not know that they had changed the time frames now. And then on top of it, my watering days were originally Tuesdays and Thursdays the last time I had checked. Now they're Mondays and Thursdays, I believe, but I only water my grass one day a week. So now it's not the days, it's the time frame. Excuse me, I have bad sinus infection. So it's the time frame that's wrong, correct?
Yes, ma'am. When this occurred, this was under the previous days, but it was the time frame that was wrong. Yes, ma'am.
Okay. Okay, thank you.
Yes.
You have the authority to enforce the $100. You can reduce the fine if you want to. You can do whatever you want with these. So you can reduce the fine, you can eliminate the fine, you can make whatever doing any of that.
Okay. You're aware of the time frame now.
Yes, sir. I even had people check to make sure that it was right now.
Okay. I'm going to go ahead and dismiss this case. You're done.
Okay, thank you very much.
No fine. You're okay to go.
Okay,
But
thank you.
make sure it don't happen again.
Well, see, when I was gone in 2019, I got a letter saying that there was something, my watering days had changed.
Yeah.
So my friend went on ahead and changed it for me. So she had the individual that was writing it up change the dates on my house.
Well,
But I don't plan on being
you don't want
employed
to see me
anymore.
again.
So
You don't want to see me again.
it's okay. Thank you very much, sir. Thank you.
He was just joking with you. He was just joking.
Well, it's okay. I try to do everything well.
Yes, ma'am. Thank you for coming in today.
Ready to go? Okay, we're going to go to the beginning of the agenda and get the water and false alarm cases done first, just to get them out of the way. So go to page 1, number 1, under false alarm cases. Case number BA 129300. The owner is Ribi A. Hamad. The violator is Delta Import and Export, 14975 North Nebraska Avenue. We have service and no one is present.
Case BA 129300, data false alarm 13122 to 622 10/6/22. Amount due $1,200. This gentleman called and asked for a little bit of time to make payments on this because he can't afford that.
Is the county in a process that they can accept payments on time?
Yes.
They can?
Mhm.
So when did he contact you?
After he received the notice of the hearing.
Which is,
I don't have an exact date when it was that he called.
and what do you recommend?
He's made 2 payments since he received the notice of hearing of $150 each, and I'm thinking that's what he wants to pay is $150 a month. So I guess that would be 8 months.
8 months? You're okay with that?
Yes.
Okay. Okay, I rule in the case of BA 129300 that based on the evidence presented, the violator has failed to pay the false alarm penalty fine imposed by the county ordinance 4-16. I grant the violator 240 days to pay the fine imposed in the order and that the payment be made by that date. A fine of $150 a day will be assessed.
Next case is number 2. Case number BA 124824. The owner is Liberty Property Limited Partnership. The violator is Ryder, 9110 King Palm Drive. We have service and no one is present.
Case BA 124824, data false alarm 7922, 81322, amount due $625.
Nothing done? No response?
No.
What do you recommend?
I'm not sure. I mean, the
What do you think is fair?
15 days.
Huh?
15 days.
15 days? Okay, I'm kind of a crazy guy here. All right, I move in a case of BA 124824 that based on the evidence presented, the violator has failed to pay the water resource penalty fine for illegal sprinkling. Oh, I'm sorry, I'm wrong case. I rule in the case of BA 124824 that based on the evidence presented, the violator has failed to pay the false alarm penalty fine imposed by the county ordinance 4-16. I grant the violator 15 days in order to pay that fine imposed, and at the order that the payment is not made by that date, a fine of $100 per day will be assessed.
Page 3, number 3, BA 131280. This case complied March 29, 2023. Number 4, BA 131516, complied April 10, 2023. Page 4, number 6, BA 1115. This case complied April 3, 2023. Page 5, number 7, BA 128644, complied April 5th. Number 8, BA 111134A. This case complied February 28, 2023. Page 6, number 9, BA 113167, complied March 21, 2023. And number 10, BA 129452, the owner, Jatim Habercorn Barrios, 6904 Soledad Court. We have service and no one is present.
Case BA 129452, data false alarm 9122, amount due $75.
And you have no contact with the owner?
No.
Okay, what do you recommend?
The 15 days is good.
Okay, I just want to get a feel for it, you know.
Okay.
Okay. All right, I rule in a case of BA 129452 that based on the evidence presented, the violator has failed to pay the false alarm penalty imposed by county ordinance 4-16. I grant the violator 15 days to pay the fine imposed in an order, and that the payment is not made by that date, a fine of $100 per day will be assessed.
Number 11, BA 130541. The owner is Hawkstone CDD, location 14155 Swiss Bridge Drive. We have service and no one is present.
Case BA 130541, data false alarm 61022, amount due $75, and no contact from the owner on this one as well.
Okay. I'm getting consistent. Maybe you're not liking it, but I rule in a case of BA 130541 that based on the evidence presented, the violator has failed to pay the false alarm penalty fine imposed by County Ordinance 4-16. I grant 15 days to come to pay the fine imposed, and in order that the payment is not made by that date, a fine of $100 will be assessed per day.
Page 7, number 12, BA 131072. This case complied April 13, 2023. Number 13, BA 131992, complied April 4th, 2023. Number 14, BA 9142. The owner is Charles D. Granruth, 7012 Conifer Drive. We have service and no one is present.
Case BA 9142, data false alarm 92422, amount due $75.
Okay. I rule in the case of BA 9142 that based on the evidence presented and the violator has failed to pay the false alarm penalty fine imposed by the County Ordinance 4-16, I grant the violator 15 days to pay the fine imposed. In order that if payment is not made by that date, a fine of $100 per day will be assessed.
That concludes the false alarm cases. Thank you.
Hope you're happy.
Next, now turn to page 8 under water ordinance cases, number 15, WR 202434. This case complied April 7, 2023. Number 16, WR 2202575 was pulled per staff. Number 17, WR 2202592. This case complied April 13th. Page 9, number 18, WR 2202648. The owner is Matthew Bradford O'Neill and Kylea Rochelle O'Neill, 11435 Sage Canyon Drive. We have service and no one is present.
I don't know, 6. There it goes.
Good morning, David Kanzler, Hillsborough County Code Enforcement. Case WR 2202648. On Wednesday, the 2nd of November 22 at 0637 hours, Officer Baker arrived at 11435 Sage Canyon Drive to observe the sprinkler system in the rear of the home operating. This is in violation of County Water Ordinance for watering on non-watering hours. The location is south of the Alafaya River. This is the 4th offense for this location. Assigned watering days are Wednesdays, but the hours are 8:30 to 12 and 6 p.m. to midnight. The notice of violation was issued on the 30th of November 22. It went into default the 4th of January of 23. The notice of hearing was posted after attempted hand delivery on the 29th of March 23. For the history, there was a warning issued in July of 22. Then there was a $100 fine in September of 22, which was paid. And there was another fine in October of 22 for $200, which was paid. This fine will be $300. There's been no movement on this since the fine was issued.
No contact with the owner?
And no, previously, yes, but nothing, no
Nothing on
contact
this
this
one.
time. Yes, sir.
Yeah, so he hasn't learned his lesson, huh?
Well, I will say in his credit, at least he's paying the fines when he's getting them.
Yeah. Well, we got to create an incentive, right?
Sometimes, yes, sir.
All right, I rule in the case WR 2202648 that based on the evidence presented, the violators failed to pay the water resource penalty fine for illegal sprinkling imposed by section 111-7 Hillsborough County Code and Ordinance and Laws at Public Utilities. I grant the violator 15 days to pay the water penalty fine imposed, and if payment is not made by that date, a code fine of $100 per day be assessed.
Number 19, WR 2202650. This case complied April 7, 2023. Number 20, case number WR 2202669. The owner, Terrence Alshon Fleming and Joanna Faye Lene Fleming, 9844 Ivory Drive. We have service and no one is present.
David Kanzler, Hillsborough County Code Enforcement, case WR 2202669. On Friday, 4 November 22 at 05:10, Officer Baker arrived at 9844 Ivory Drive to observe the sprinkler system on in the rear of the home. This is a violation of county water ordinance for watering on non-watering days and during non-watering hours. This location is south of the Alafia River. This event is the 5th offense for this location. Assigned watering days are Wednesdays only and watering between the hours of 8:30 and noon and 6 p.m. and midnight. The notice of violation was issued on the 1st of December of 22 and went into default on the 4th of January 23. The notice of hearing was posted after attempted hand delivery on the 29th of March 23. For the history of this property, April of 22, there was a warning issued. May of 22, a $100 fine was issued, was not paid, and with daily fees, daily penalties, the second violation is up to $1,900. In July of 22, the third violation for $200 was issued. It's unpaid, and with penalties, that individual fine is up to $2,000. October of 22, a $300 fine was issued, unpaid, and it's accrued to $500. This fine will be for $400 plus whatever the magistrate issues if they don't pay.
Oh,
And there's been no contact from the owners.
and what would you recommend?
I would say the same thing that you've been doing for the alarms, 15 days and $100 a day would be my suggestion
Okay.
for consistency's sake.
Well, I don't know, when somebody doesn't follow the rules,
5 infractions,
yeah,
so.
and have been paid
It's
for
at
the-
your pleasure, sir.
yeah, well, thank you, I appreciate that. I don't get that often. WR 22020, I rule in the case of WR 2202669, that based on the evidence presented, the violator has failed to pay the water resource penalty fine for Hillsborough sprinkling imposed by Section 111.7 Hillsborough County Code and Ordinance and Laws, Part B, Public Utilities. I grant the violator $5 days to pay the water penalty fine imposed in order that the payment is not made by that date of code fine of what can I, is there,
Same thing as any other. Same limits as
$1,000 a day.
Huh?
$1,000 a day is the max.
$1,000 a day be made by that date? Okay?
Yes, sir.
Next case, page 10, number 22, WR 2202679. The owner, Shamikia Keaton and Michael Harrison, 12406 Ballantrae Forest Drive. We have service and no one is present.
David Kanzler, Hillsborough County Code Enforcement, case WR 2202679. On Tuesday, 15 November of 22 at 0642, Officer Baker arrived at 12406 Ballantrae Forest Drive to observe the sprinkler system in the area of the front yard on the right side of the driveway in operation. This is in violation of the watering ordinance for watering on non-watering days and non-watering hours. This location is south of the Alafia River. This event is the second offense for this location. Assigned watering days are Thursdays only. Watering hours are between 08 08:30 and 12 noon and 6. The notice violation was just issued on the 2nd of December of 22. Default was on the 4th of January 23. Notice of hearing was posted on the 29th of March 23. For the history, this property was issued a warning in October of 21. This fine's for $100. There's been no contact with the owner.
What happened on the first case?
They,
You said
they were given a warning.
that's it.
That was, the first case is always a warning.
Okay, okay. Okay, we're gonna stay consistent. I rule in the case of WR 2202679 that based on the evidence presented, the violator has failed to pay the water resource penalty fine for illegal sprinkling imposed by section 11.7 Hillsborough County Code and Ordinance and Laws, Part B, Public Utilities. I grant the violator 15 days to pay the water penalty fine in order that the payment be made by that date. A code fine of $100 per day will be assessed.
Thank you, Mr. Magistrate.
And that concludes the water ordinance cases.
Wow, we're moving along here. Maybe. Okay, next case.
Are you ready?
Yep.
Okay.
Am I ready?
Turn to page 12, number 25, landscaping and natural resource cases. Number 25, L 227543. The owner is Bayside Transfer LLC, 5502 West Linebaugh Avenue. We have service and we have a representative here. Good morning, good afternoon.
Good
Excuse me.
afternoon, Sam Aref. I'm with Arefco International, 13250 North 56th Street, Suite 202, Tampa 33617.
I understand you're the attorney. Are you representing the property owner?
I'm the engineer representing the property owner.
Okay, thank you.
Thank you.
John Beavers, Environmental Investigation Supervisor with the Natural Resources Unit of Development Service. In L 227543, owner violator Bayside Transfer LLC, violation address 5502 West Linebaugh Avenue. Violations observed, unpermitted encroachment within a wetland setback. Ordinance violated section 4.01 LDC. First inspection, July 15, 2022. First notice, December 14, 2022. Last inspection, March 31st, 2023. Inspections conducted 3. Turn this over to the investigation officer, Wayne Doyen.
Morning, Wayne Doyen, Hillsborough County Natural Resources. Just want to start out first. We've been in contact with Sam and the owner throughout this process. This came to us through the permitting, through our planner. He notified me of some incorrect stuff on the plans and the buffering, the wetland setback. So our first slide here is this is the site plan they're turning in for this property to construct a business. The yellow highlight area is where the wetland setback encroachment area is. So this is the only area right now that's in question. Next slide. This is on July 15, 2022. This was taken from me. This was the alley where that yellow highlighted section was. Just a small section as of right now. Next picture. This is my recheck of the property. Like I said, they are going through planning. They're working with EPC right now to mitigate the wetlands, which would also mitigate some of our wetland setback for that area. They'll have to do some wetland plantings, but the permitting is going to take a while. We've added that into our staff recommendations. But as of right now, they are working with us. They are trying to get this done properly through all departments. Next slide. Staff recommendation: remove all fill within the wetland setback area and complete the wetland setback mitigation within 90 calendar days, or submit commercial construction plans within 90 calendar days, obtain a permit and complete mitigation plantings within 210 calendar days. The owner is responsible for resolving this matter with the county. Fines will be issued for failure to meet timeframes.
Okay,
That's it.
yes, sir.
Okay. My firm was hired sometimes last year, I can't remember when, and part of the due diligence before we start the project, we check on the property. And I'm going to admit I made an error, and Wayne is aware of that error. I found this letter, it's a variance approval for a 30-foot, for 24-foot reduction from a 30-foot setback to 6 feet. And I was happy to see this, surprised but happy. So we started the project, and our initial submittal showed exactly like what the letter said, 6-foot setback line from the wetland. And nothing, we're not hiding anything. Here's the letter. I can leave it with you. Show the 6-foot line, and that's what was submitted to the county. With support of this letter, during the initial review process, I became aware, or through comments saying, no, that 24-foot reduction is because of adjacent land use. It has nothing to do with the buffer, with the wetland. So I did some investigation and I found out, yes, I was wrong. So then we made a second submittal, which shows that now we have a 30-foot buffer from the wetland line, and ultimately got the plans approved under the first preliminary process. So I do have that letter to show that it has been approved. Wayne and I, we've been talking a few times, and he knows, I hope he says that I did say that's my mistake in the due diligence process. Here's the approval letter with the correction of the 30-foot wetland line. I met with EPC, met with FDEP, and with county, and they're all aware what's coming to the project. There will be impact to the 30-foot buffer as well as minor impact to the wetland because of the property is restricted right in the center. You cannot access the south end of the property, which is a large area, without impacting the buffer or portion of the wetland. So we're in the process of doing that, and we're showing that with our final construction plans that are currently under review with the county. As far as the dates, I think the dates are accurate. If the county is on schedule with 30-day review and comments, and we're on schedule responding efficiently, we should get the permit showing that impact will be resolved both for the 30-foot buffer line as well as some minor impact to the wetland. So that's where we're standing.
So you would agree with what the county staff recommendation is to submit the commercial construction plans within 90 days?
Absolutely. Yeah.
Absolutely. Do you have any problem with that?
No, I do not, as long as Wayne doesn't have a problem with that either.
Dayton, do you have a problem with that?
No, we're in agreement with this recommendation.
Would you, I'm not familiar with this total process, but would you entertain a continuance of this case for 90 days, or do you?
If you want to, you can do that. But
Let's just do a continuance on this case, and you can come back and give an update, or if the
Sure.
county then is satisfied, they'll just shut the case down.
Sure, if there are any hiccups, I think we can be,
Sure.
and if Wayne
Sure.
can correct me.
Can I just interject real quick? John Beavers, we are in contact with the engineer through this process, and that the manager of natural resources, seems to believe that this is an adequate amount of time, and it's in agreement with the engineer. So we'd like to, if it's your choosing, like to move forward with it.
With the
You know,
90-day
with-
continuance?
Yeah, without the continuance. Yeah.
Oh, no, you're saying no?
No continuance.
No continuance?
Yes, sir. But that's up to you. Yes, sir.
But if there is any hiccup in the process, can we request additional days?
You'd have to come back and, oh. if you-
Because we're dealing with FDEP, we're dealing with EPC, and we're dealing with the county, the various departments at the county. Somewhere along the way, getting a permit is not as easy as one thing, especially clients. They think we can get it for them tomorrow, but it's really not the case. We're dealing with 3 different agencies. I'm saying we're gonna meet that schedule, but just in case some agency throws a kink in there, because DEP and EPC do not align. DEP does not believe in a 30-foot buffer. They don't acknowledge that. EPC does, as well as the county.
Okay,
I mean, I was told by DEP, why would you impact wetland to create a buffer? That's exactly what we're doing here.
okay.
Right now, we're given like 210 days. What do you propose?
I'm saying we're gonna meet them, but I don't know what the future holds. I really don't.
Yeah.
Permitting is very hard.
Based on the fact that there's cooperation going on between the parties, I'm a little bit less likely to put a demand on it. I want to go ahead and continue the case for 120 days. Okay?
And that will be to the hearing on August 11th, 2023.
August 11th. Do you want copies of these, by the way?
Yes.
Okay.
Yes, please. So then hopefully it'll be resolved before that time, okay?
Believe me, the next time I come, I'm gonna give you an approval letter.
Okay. When people work together, I like,
Yes, sir.
You said August 11th, correct?
yes. You'll
That's
get a
right.
notice
We'll
in-
send you an order of
Okay,
continuance.
all right.
Okay, thank you.
Thank you. Thanks, Wayne.
Got one more case like that? It's all the green screen. Is that
Ready for,
fair? Is that fair?
ready for the next
When
case?
people work together, I'm not as hard on them.
You ready for the next case?
Yep, ready for the next case.
Okay, next case is number 26, case number L227572. The owner is AJ&E Properties LLC, and the location is a vacant property on Austin Street, east of 50th Street. And we have service, and we have several parties signed in for this case.
Okay.
And I need to give this gentleman the oath of witness. Please raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And state your name and address, please.
My name is Jose Luis Urena.
Can you get into the microphone?
I'm sorry. My name is Jose Luis Urena, 2808 South 63rd Street, Tampa 33619.
Thank you. Are you the owner?
Yes, I am.
Thank you.
And you have to do it again.
Okay.
In addition, there's another party here that we need to get on the record as well.
No.
Dennis? Is there a Dennis? Raise your right hand, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
And state your name and address?
Dennis Bacon. I'm here on behalf of the property owner that's affected by these violations. The property is 5025 Hartford Street, Tampa.
Thank you.
Sam Arefco International, 13250 North 56th Street, Suite 202, Tampa, Florida, 33617. I'm the engineer for Mr. Jose.
Okay.
Hello, this is Jim Rauch with Hillsborough County. The owner of the property is AJ&E Properties LLC. There is no address to the property. It's folio 46975.0100. Violations, unpermitted disposal of fill in a flood zone. Ordinance violated section 4.01. First inspection is July 1st, 2022. First notice, August 12th, 2022. Last inspection, April 4th, 2023. Total inspections, 5. Okay. I was called out to the property on Hartford Street next door. This is what I found at first inspection. Their bay was flooded. Their retention pond, which is on the left picture in the background, was overflowing. And the violation property, you can see in the back to the left on that picture is where the semis are. The entire property is in a flood zone. The next case, case L227573, is going to involve the property to the left of the red square. He owns both properties and his business is on both of them. So they're going to be identical cases, just 2 different folios. This is the site he's currently using it to park semis and vehicles on. If you look at the above part, I don't know if I can put my cursor on here. No, yes. Okay, where the cursor is on, that's one folio, and here's the other folio. This is a 2011 LiDAR image, and it shows the elevation with the blue and the white being pretty low in this area. Similar to the area next door where the blue is the retention pond. There's also a drainage swale that runs along the east side of the property. The picture on the right is before the property was purchased and used. It was vacant and kind of being used as a dump. It was in pretty bad shape, but it was left natural. You can also see the retention pond area was overgrown on the property on Hartford Street. This is comparing the 2016 aerial to the 2022. There's been fill brought into the entire property. It's approximately a foot over. We haven't done any measurements to the properties around it, but just from eyeballing, there's railroad ties around the edge of the property, and how high the property is, it appears about a foot higher than the neighboring properties. Were no permits pulled. There's no business plan. Transportation hasn't reviewed it. Nobody's reviewed this. This is the April 4th, 2023 picture. Again, it's hasn't changed on the lot, and you can see on the picture on the right, the elevation change from this lot to the next lot. Staff recommendations are remove all fill, restore to the natural grade within 90 calendar days, or submit a natural resource permit within 90 calendar days. Obtain a permit and complete the mitigation within 120 calendar days. The following items must be included in the application. Submit a professional engineer's plan or certified floodplain manager's report. Provide an as-built plan for the final grading elevation. The owner is responsible to resolve this matter with the county. Fines will be applied for failure to meet with these timeframes.
Okay, who would like to speak first?
Go ahead, speak first.
Okay, when I first bought that property, when I got to that property was to help a person to clean it because I have a tire shop. He came to me to ask me how to dispose that because that property was used. The people in the front of the property, they were using it to throw tires and a lot of garbage and demolition. I have a lot of pictures where they were showing that tons of tires from the sky. So what we did was helping him. I was helping him, then he offered me to buy the property, which I did. But we removed from there anywhere between, because I count by the containers, we remove about 7 to 8,000 truck tires and a lot of demolition. And for what I believe, all what we did was like we put some fill, but just to cover, like we remove from there because, we don't put that much. And for all the past years, I've been there for 5 or 6 years, never we got that problem with the water till the people next door last year, they removed a wetland. I got pictures of the big wetland. We never got that problem over there because that water, when it rains a lot, even comes to my property because there was a huge wetland that is shown over there and it was connected. There's a ditch on the back of those properties, a big ditch. It's made, I guess, by the city or whatever. The water goes straight to there and goes away. But when they destroyed this wetland last year, and they did how they call retention pond, that's how they call that, the water got no way to go. The water stays there, and if, of course, it rains for a few days, like last year, we got days like for three weeks raining every day, that water got no place to go because when they did the retention pond, of course, the water goes in there, comes from the neighbor on top of them, from my property, and from everywhere. The water goes over there naturally, but when they did that, that water is not going to go nowhere. That water is going to stay there. And like what I was telling the code enforcement the other day, they know what they're talking about. I don't know too much about that, but I've been there for 6 years. We never got problems over there till they broke down that wetland. That if you can see on the pictures, it's a huge wetland. The wetland is not there no more. When they took this wetland down, I was like scratching my head because I said, how can they take that wetland when there's a lot of animals there, a lot of birds? That was a natural place for animals. They destroyed. I don't know what was the reason. They have permits or no. But I knew since when I saw they doing that, I knew we were going to have problems. Now, when it rains a lot for a few days, again, that water is going to go nowhere because of the retention pond they did. Before, when the wetland was connected to the ditch that is in my property, every time it rains in my properties, the water goes all the way to the back to the ditch. Now, the water that goes on their side is never going to come out. And the longer, if they don't change that wetland, I'm not here to tell people what to do, but I'm trying to tell, we never have the problem before till last year when they removed that wetland, which was huge wetland. There was a lot of trees, and there is not even one tree right now over there. The trees that you see few are on my side. And of course, when they did that, they removed a lot of dirt. Of course, now my property looks higher than property because of all the stuff they removed because when they removed the wetland, after they removed the wetland, they did that retention pond. And again, the water has no place to go. If we got rains for a week, I'm sure it's going to happen again. And no matter what I do, if that retention pond stays there, it's going to happen no matter what we do on our side. And I'm sorry, that's what I have to say.
Okay, thank you.
I met Jose toward the end of 2017. He called me on the property to see what he can do to develop it. And since 2017, after he cleaned it up, and what he's saying is that he leveled the property since he removed a lot of dirt there. He got a lot of potholes, so he brought in fill to level it. I have not seen that property since 2017 being filled or even developed, besides just bringing trucks and trailers. And we're talking 2017. The complaint from the adjacent property came, I believe, last year. And when I looked at the property, the only thing I could see, and this case is not unique, it happens all the time. When you have a new development that change the terrain of the property, you will have stormwater issues. Since 2017, I keep stressing, until last year, there was no complaint, no runoff to any adjacent property except to the wetland. But once that development happened, now we have issues. Issues not caused by Jose, issues caused by the that property that was just developed. So that lies where the issue is. It's not from Jose, since the property was not touched since 2017. I will tell you, there's a lot of issue on his property. The fire marshal was there. The police is always there at the entrance on Austin Street. People dumping garbage, and I'm not sure if any of you is aware of the problem. You may have, yeah. He called me last week. He said, should I clean it? Because I really want my property clean. I'll admit to you, I told him, no, don't clean it. Why? Because they're gonna fill it again. He's not listening to me. He's cleaning it now, and he's got pictures to show you. But I will assure you, give it a few months, you're gonna see similar garbage again being built up. Inspector's gonna walk into his property, and they're gonna find issues, and they're gonna cite him or violate him for different things. But they're not looking at what the next door development caused that created this flooding. I urge the county to review the plans, especially the drainage plans, to see if the wetland was permitted to be impacted or the stormwater pond was adequately designed that contain all the runoff on their property. And I will submit to you, we can survey the property now, which may cost about $4,000, and hopefully show you that there is no runoff going to adjacent property. It's just because it got built up because of development, now they have issues.
Can I ask you a question?
Yes.
When you spoke with him in 2017, did you say that he should probably go through a pre-submittal meeting and find out if he's legal to do a business on that property and fill it and not have a retention pond and not have a review by transportation or the fire department, zoning? He didn't have any review for anything. He just came in and filled property. He admitted himself they filled property. It's in a flood zone. You can't bring any fill. It's cup for cup compensation. So he needs to have a retention pond to control his own stormwater. As for the property next door, they got an EPC permit. The pond was already there. It was overgrown. The property, I believe, went through, if he'd come up, I think they bought it recently, and the old owner didn't complain because it wasn't an issue for them. They want to use their dock, which is completely underwater. I mean, they can't use their property. And your property's raised a foot higher than theirs, but if we look back at the LiDAR image, this blue area here at the folio should be much lower than what it is, but right now it's level with the property to the left of it. So I don't know how you're trying to say that there was no change made. He filled in low areas. Well, yeah, he filled in a low area in a flood zone, and now it's flooding a neighbor. He needs also to go to find out if he's even legal to run this business here. Okay. Transportation wants to review it to make sure if you got semis pulling in and out of there, that it's doing it safely where it's not going to impact people on Highway 41.
Sure. To answer your initial question, when I met with him in 2017, the reason we met to see how can he develop this, what's the best use or that he can maximize the usage of the property. We did not call for pre-app because we did not submit any plans, and we just discussed the potential of developing it, but we didn't go any further. But in saying that it got filled, yes, I did say that. We leveled it. I wouldn't call it fill. When you remove, I don't know how many tons of trash he said, but when you remove that, you're removing dirt with it. So he brought in fill to level it, but not to raise it. Now, the only thing we can go back and forth, you and I, but I think survey would best help this issue in here to see which way the water was flowing, which way the water was not flowing. We can get into a 1984 contour maps from Swiftmud. We can go as far back as that. That gives you 1 foot contour, and we can show you this is how the property is. But
right, but the pictures here are showing that you're about a foot higher than
I
the
can't tell
neighboring
by,
property.
please forgive me, I can't tell by the picture, the elevation or how high they are. I cannot tell. You and I discussed this on the phone, and I gave you assurance, whatever the county requires us to do, we will do it. At the time, I did not know about the development next door. Again, I've been doing this 33 years. This is not a unique issue. But whenever there is a development, more impervious area is put on site or the site is raised, you will have problem if it's not designed and constructed properly.
The
I would
property's
like to
been
see
there. It
the
hasn't been
as-built.
developed. All that changed was they cleaned out the wetland area. They got a permit from EPC to clean that. The building was already there.
Didn't they build something?
Okay, I'm gonna,
The picture shows here, you know, I've been there.
I'm gonna take a break for 1 second. There's a young man that wants to talk.
Again, my name's Dennis Bacon, and I'm here on behalf of the property owner on Hartford Street. Just to clarify, we purchased the property, or the owner purchased the property in 2020. Shortly thereafter, he incurred significant costs or expenses associated with engineering, permitting, and construction of enhancements to an existing stormwater system. The existing system was 3 small ponds, retention ponds, and basically what we did was create 1 larger pond. In addition to that, along the southern property boundary, it was very heavily, densely vegetated with exotics, Brazilian pepper, and as part of that construction process, we removed the Brazilian pepper. That was all permitted through the county. During the construction of the improvements is when we discovered that we were receiving runoff from the adjacent property to the south. To the extent that while we were laying sod during a rainfall event, the water intrusion was so violent that it was actually displacing the sod and eroding the berm of the retention pond. Again, they were cited probably 10 months ago. The condition still exists. During rainfall events, it overwhelms our stormwater system. It overflows into the parking lot and the loading dock, which makes it portions of the property unusable until the water can recede.
Okay. Thank you. All right, you can go back.
I'll tell you the best way to really solve this issue or see what the issue is to review the as-built plans and to review the design of the stormwater pond. That tells you what the existing condition was before, and it tells you what the issue is after the proposed. But back to your question, was it reviewed by transportation? It doesn't need to. It has not been developed. Was it reviewed by natural resources? It doesn't have to. It has not been developed.
Yeah, but you.
Stormwater, it has not been developed.
You can't turn it into a truck parking lot and store trucks there and do open storage without going through a review.
If the zoning is manufacturer.
This heavy industrial.
Heavy industrial. You can put that in heavy industrial.
Can I say something?
Yes, you want to say something?
I knew before I bought that property, that used to be a parking lot. And there was containers and buses and a lot of things over there. The people that bought it, they stopped making the payments. And that's when they were letting people dispose garbage and charging to dispose garbage. And they stopped parking trucks and stuff. And then when I bought it, there was grass, but there was some areas that they were without grass because that used to be a parking lot for years and years. And there was pictures back behind. It's too bad that I don't have because that's a mistake. But there is pictures showing where there were a lot of containers inside that property before I bought it.
If you look on Google Earth, you go many years back, you see a lot of yellow buses being parked there. We did not change the property except clean it and fill large depressed area.
And that's what we're here about is the filling. You can't fill the property without a permit.
But look at it this way, James. We removed 8 tons of
That
trash.
doesn't matter to me.
Should we bring it back?
Doesn't matter to me.
Should we bring it back?
I'm here about the fill, not about the trash that you removed off the property.
But part of the removal was dirt was removed because trash was removed. It was just dug out.
Okay.
All he did is
We're
level the
not gonna-
property.
We're not going to get an argument here. All we're going to do is get a result. What were your recommendations?
May I say one more thing?
You're at 9.5 minutes, so.
Okay, I have 30 seconds. James and I talked on the phone, and I thought you and I agreed whatever the county wants us to do, we will do. We're not saying we're not going to do anything, but we're asking the county, please look at the whole issue. Look at both properties, not just one, and say that's the culprit, because it's not the case.
Well, if you feel we need to open a case on the neighbor, we can do that and we can investigate it.
Whatever makes you happy.
The county recommendations are remove all fill to natural grade within 90 calendar days, or submit a natural resource permit within 90 calendar days, obtain a permit, and complete mitigation within 120 calendar days. The following items must be included in the application: submit a professional engineer's plan or subplane manager's certified floodplain manager report, provide an as-built plan to the final grade and elevation. The owner is responsible to resolve these matters with the county. Fines will be applied to failure to meet these timeframes.
How do you,
That's nothing different than what you first presented. Apparently, there was no communication today, because you still repeated the same opening.
Right, because you need to submit a plan where
Plan
he's
for
going to
what?
create some type of stormwater pond where he's not going to flood his neighbors.
James, I better not say this. There is no plan to submit. Please tell me, you guide me, tell me what, just to show you a pond, submit a pond just like that? I'm telling you, there was no fill. Here's what I will do. We will survey the property. If it's different than 2017 or 2016,
How about the 2011 LiDAR?
he bought the property in 2017.
It doesn't matter. If it's been filled, there's a violation and you're responsible for it, even if you're the new owner.
Okay, but here's what I will do if you give me time. Those times are too short. I will investigate the property and to see if there was fill. And we will survey it now in current time and to see what the difference is. And then I will report back to you. And then I will tell you whether the client, the property owner, wants to remove whatever shows on the survey, the difference, or he will create a stormwater pond to hold the runoff on his property.
Well, we've been at approximately 9 months already with no restoration, no nothing.
You and I talked on the phone last month. I got involved last month.
Right, but I'm saying the owner hasn't done anything.
Because the owner owned the property since 2017 and didn't hear that complaint until last year.
how much time are you asking for? I mean,
Sure.
this has got to be accelerated. This has gone on for 9 months. I want a quick resolve on this.
Okay, I'll give you surveyor schedules. Surveyor schedule to get somebody out there, I need 6 weeks, please. And for me to get involved and do a lot of research on this,
I can recommend a surveyor be out there next week, but go ahead.
give me, I'm sorry, what did you say in there? 100, what is that, 4 months?
90 days,
Okay.
obtain a permit,
No,
120 days.
I would request that once we do more homework and we have a survey in hand, is come back here and present that to you before we submit for any permit.
Do you have a problem with that?
I'm sorry, could you state that again?
I said I will request from the county to allow me time to do more homework on the property to see how much fill that was, how the runoff was,
How much
and
time?
in which direction.
How much time?
Be
Be realistic now, not.
Of course. Give me 120 days. 90 days to 120 days.
That's acceptable, but we need heavy fines after that because the other gentleman's business is being flooded. He uses.
And we're rainy season's coming right now
Rainy
too,
Season's coming.
right?
Yeah, what I will do is I'll research the county and look at their as-built and look at their design and see if there is anything I can help them with. Because the way I keep hearing from James that he already knows the problem 100%. I'm standing here and I tell you, I do not know where the problem is. You cannot be 100% sure and tell me. You cannot.
Well,
See
you
that
already,
the property's higher than the neighboring property.
But you're also ignoring the recent development that happened on that property.
all right,
There
that,
was no
we're not
recent
going, no,
development. It
we're
was
not
cleaning over
going back
retention
and forth.
pond.
We're not going back and forth. How much time?
Give me 120 days and I'll have a clear response to you.
I would prefer as what the county is recommending, the or submit a national resource plan, 120 days. If you fail to make that, then you going to be imposed a fine. Okay? That's just, you got to get your, right, if this guy can't do it and he makes errors, you got to do. Okay? All right, I'm going to go ahead and rule.
One final word?
Can I say something?
Not too long, you got 22 seconds.
I mean, I'm here to try to solve a problem because what I say, since I bought the property, all what I've been doing is cleaning and cleaning. I mean, you guys don't know, but I spent over $100,000 just to clean the property. Now I'm cleaning the front, and the whole problem I have right now pretty much is because, it's a lot of garbage is putting in that property, which is not my fault. But one of the things that I wanted to say, I will do whatever you guys want us to do. I'm okay with that. But no matter what I do, his property is going to have problems because the property on top of him is even higher than my property, the one on top of him. And I don't know why he's looking only at my property. But like what I say, for 7 years I've been there, never got flooded till they removed that well
Okay,
lamp.
now you made him aware of that,
Yeah.
so that's fine, but.
Yeah, I just don't want to put nobody in trouble, but
We're looking at your case.
Yeah.
Okay? Yes,
One
sir.
final word?
You got 18 seconds.
Okay, so the flooding condition existed prior to us purchasing the property. The previous property owner told us that there was flooding issues. We knew that when we purchased the property. That's why the current owner knew that he was going to have to make some enhancements to the stormwater system. So the fact that we redesigned our stormwater system had no effect on the flooding onto our property. That was a pre-existing condition. And, I don't know how they can claim that they're managing their stormwater on their property when there's obvious evidence that it's encroaching on our property.
Okay. Thank you. Okay. I'm going to go ahead and rule in the case L 227572 that the owner has to submit a natural resource permit within 90 days, obtain a permit and complete mitigation within 120 days. Following items that must be included in this application: submit a professional engineer's plan or certified floodplain manager, CFM report. Provide an as-built plan for the final grade elevations. The owner is responsible for resolving these matters with the county. Fines after the 120 days will be assessed at $250 per day. Okay? That's it. Want my surveyor's number?
Please. We're always looking for surveys.
Okay. Give me a call.
Thank you.
You're the
We're not done
magistrate.
yet. We have the other
We have
folio.
another
It's
case.
going to be the exact same case,
Oh, okay.
but he needs to make a ruling on the other folio. It's going to be the exact same.
Well, at least I
Okay.
can go, man.
Do we sit down or we stand here?
Case L 227573, owner of the property is
Can
H&E Properties LLC.
I call the case real quick and then you can start? Page 13, number 27, case number L227573. The owner is AJ&E Properties LLC, location 2808 South 63rd Street. We have service, and we have the same parties present that we had for the prior case.
All right.
And could you all just name and address again for the record on this case?
Luis Urena, 2808 South 63rd Street, Tampa 33619.
Sam Araf, 13250 North 56th Street, Suite 202, Tampa 33617.
Okay, thank you, gentlemen. He's going to call the case. Are you going to come up?
Dennis Bacon, on behalf of the previous property owner, current property owner, excuse me, on Hartford Street, 5025 Hartford Street.
Okay, thank you. Gentlemen?
Me. All right, case L 227573. The owner is AJ&E Properties LLC. There is no violation address. The folio is 46974.0000. Violation unpermitted disposal of fill in a flood zone. Ordinance violated is 4.01. First inspection July 1st, 2022. First notice August 12th, 2022. Last inspection April 4th, 2023. 5 inspections conducted total. Property was flooding. A neighbor next door, he called in. We came out and investigated, found the property was flooding. We found that the property next door has been filled. 2 folios, the entire site is in an AE flood zone. Property has been filled and trucks parking on it. LiDAR image shows that it was the same or lower elevation than the property to the next door to the north. 2016 aerial shows the property undisturbed. The parking lot compared to the 2016 aerial. And the final inspection was April 4th, 2023, and the property is approximately a foot higher than the neighboring property. There is no stormwater pond on the property control there. Stormwater. Staff recommendations: remove all fill to natural grade within 90 calendar days, or submit a natural resource permit within 90 calendar days. Obtain the permit and complete mitigation within 120 calendar days. The following items must be included in the application: submit a professional engineer's plan or a certified floodplain manager's report, provide an as-built plan as to the final grades and elevation. The owner is responsible for resolving this matter with the county. Fines will be applied for failure to meet these timeframes.
Okay. Same story.
Same answer.
Same
Same
story.
answer.
All right.
Okay. All right, I'm prepared to go ahead and rule on this case as well.
Can I clarify something just before you do? The 120 days, does that run from today or from the time that the permit is?
From the time that the permit is obtained.
Thank you.
Okay. I rule in the case of L222.
Sorry, would we get a letter with that statement,
Yeah.
with those statements? Okay, thank you. Sorry.
All right. L2227573, that they need to submit a natural resource permit within 90 days, obtain a permit and complete a mitigation within 120 calendar days. The following items must be included in the application: submit a professional engineer's plan or certified flood plan manage CFM report, provide an as-built plan for the final grade elevations. The owner is responsible for resolving this matter with the county. Fines will be applied for failure to meet this time frame of $250. Okay,
Thank you.
you're welcome.
Okay, that was all the L cases. The next case,
Somebody over
we have one more case on the agenda.
there. Okay.
Page 14, number 28, under Public Works, Public Utility Cases. Number 28, ROWV-22028. The violator is Sophos Construction LLC. And the location where the violation occurred is 2817 Durant Trails Boulevard. We have service and we have some parties here today for this case. Come up now if you're here for this case to take the oath of witness.
My name is Joe Bono for Sophos Construction, 2822
You want to move
52nd,
the mic down a little?
2822 52nd Lane North, St. Pete, Florida, 23710.
And who are you here representing?
Sophos
So,
Construction.
okay.
Yeah,
And could you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. And I need to take care of this gentleman as well. If he could step over. Raise your right hand, please, sir. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
And state your name and address.
My name is Brian Smith. Address is 2817 Durant Trails Boulevard, Dover, Florida, 33527.
So are you the owner of that property?
Yes, I am.
Thank you.
Okay.
Okay.
I'm Ricardo Carnero, Capital Program, Public Work. Address 2310 Regional Water Lane, Tampa, Florida 33619. This is a violation case right away, number ROWB 22028. Violation address 2817 Durant Trail Boulevard, Dover, Florida 33527. Violator contractor name, Joseph Buno, Sophos Construction LLC Company. Violator contractor address 2822 52nd Lane North, St. Pete, Florida 33710. Violation observed, substandard work performed on the county right-of-way area without approved permit. Ordinance section violate AC section 92-22 of Hillsborough County right-of-ways use procedure manual. The history in this case, the first inspection was November 10, 2021. The first notice of violation was sent November 10, 2021. The second NOV, November 24, 2021. The third mailbox post, June 14, 2022. The second mailbox post, February 24, 2023. Last inspection of the property was April 7, 2023. The total number of inspections, 6.
Okay.
Okay, the first picture is a Google Map 2019 with the condition of the property before pour the concrete. The second one is show the issues that on the new concrete. So expansion joint, for example, was not installed in front of the concrete curb. The sidewalk crosses slope more than 2%, no according ADA requirement. The next one show the other issues, wrong expansion joint installing, poor quality of the concrete used, and other issues was deterioration of the existing concrete, wrong expansion joints. This is the last inspection to the property that was in April 7, 2023, and still appear in the same condition. Our staff recommendation. Contractor must be scheduled the work with the work in coordination with the homeowner of the property. The remedial work must be complete, and the right-of-way final inspection must be approved before the permit expire date. Expire date is the permit is June 11, 2023. The permit number approved
is AC-ROW-22-00011716.
Okay? Yes, sir. Your response.
We have no problem fixing the driveway. That's not what our issue is. We tried to get this done before, actually, what, January or middle of
Speak to the
February.
mic. Speak to the mic, please.
We tried to get this done after I met the code official out there. We had everything scheduled to get everything done, but the homeowner and I have just had issues from day one. And everybody I sent out there, he comes out, threatens them about cutting the lines and sprinklers, and they're gonna get billed back if something happens, so my people leave. So it's very hard to schedule the finishers, the Bobcat guy to remove the concrete and the concrete in this day and age with the stuff that's going on and how busy everybody is. We had it all set up. We had everything worked out so they would not be with the driver, without a driver for less than 3 or 4 days. And everything went out south. We're not denying that we have an issue with the driveway. We've said that from day one. That's not the problem. When I was called to go out there and meet with the code official, said no problem. We applied for the permit, we have the permit, and we wanted to do the work. But I can't keep sending people out there and scheduling 3 different trades to get the job done and the homeowner running them off. So until that's resolved, I have no problem doing it. I've never had a problem doing it. But from day one, it's the homeowner, don't come back on my property, don't set foot on my property. I send one of my personal guys out there to inspect the driveways just this last January. He gets run off there. The Bobcat guy comes out to remove the driveway, he gets run off. I can't keep doing work that way.
Okay,
So-
understood. Let me talk to the property owner. You the property owner? Oh, get up there. Lower that mic so you can be heard.
Good afternoon. Yes, I am the property owner, and just about everything Mr. Bono just said was a lie. I've never run anybody off of my property. Mr. Bono was supposed to schedule with us so that we just knew, that people were going to be coming out. That's never happened. We did have a Bobcat guy come out, knock on the door, unknown to us, that he was coming, and we talked to him, and his concern was that Mr. Bono wasn't going to pay him. And he said that it was going to take him approximately 4 days just to rip up the driveway. In doing so, he was going to take up my sprinklers, my cable, everything else. And I just asked him, I said, how is this gonna, can we just make sure that everything gets put back the way that it is? I've never threatened anybody. We've been going back and forth with Mr. Bono since 2021. I have stacks of emails. He has refused to, we said at one point, we want to be done with you. We don't have any faith in your work. He did exceptionally poor quality work. He's lied the entire time about saying that I told him to put in the substandard wood, which I told him, it has to look like everybody else's in the neighborhood. It clearly does not. Mr. Carnero has been nice enough to facilitate a bunch of times. He was actually there at my house when Mr. Bono came out to my house, and I believe that Mr. Carnero would say I was more than pleasant with Mr. Bono, given the history on this and the fact that it's been since 2021. We did say at one point, just cut our losses, give us a refund. We want to be done with you because we don't think that you're going to do a good job. And he texted us that, I never said that and I will not refund $1. Text to my wife. Sorry, just trying to find it. It's a big picture here. I apologize. Big text. She asked him, would you like pictures of the damage? He said, I know what is there. My wife said, okay, please let me know when you or someone will be coming so I will arrange to be home. Mr. Bono's reply on the Thursday's May 6th, I believe this was 2021. I'm not ripping the driveway out. I'm not redoing it. I will take the hit. I've already lost 2,500 on this job, and now if you're not paying me, doesn't really matter. So I will do my best to clean it up and make it look good, but that's it. He has lied to Mr. Carnero about scheduling things. He just lied to you about scheduling things. And in my opinion, I would honestly like to obtain a refund from him and cut services, and we'll go with another contractor. But I leave it up to the county because I know that there's due processes that need to happen. We have tried many times to afford him the opportunity to make it right, and he refuses, and he lies, and he says that I'm threatening people and running people off of his. I'm 5'4". I'm not in a position to threaten anyone or to run anyone off. I also would not go well with the agency that I work for to find that I was threatening people. That
Who do you work for?
I work for the Hillsborough County Sheriff's Office.
Sheriff's Office?
Yes, sir.
What do you do?
I'm a server administrator, information services.
Oh, okay.
So I'm not going to put my career on the line because of a liar.
Okay.
So
At least you're not running for a chief of police, huh?
negative. No, sir. No, I keep my nose clean. I'm a good person, and I wish that I had known ahead of time that Mr. Bono was not a good person.
All right, I'm going to have you come back up again, but I got a question on the driveway. This is just for my own information purposes. From the sidewalk to the street, isn't that all right away?
That's correct.
Yes, it is, right?
Yes,
And they need to pull a permit to do work on that?
that's correct.
Really?
Yes. Any work in the county right away requires permit.
Huh, that's interesting. Okay, all right. How are we gonna resolve this, sir?
However you want to resolve it, sir.
Huh?
However you want to resolve it. I'm open to anything at this point.
I know you have a contract, all right? And, I'm not gonna ask you to give them a refund because that's not appropriate. I've been a contractor all my life. Okay, I want you to, both of you, to stand right here, right now, and come up with a date when you can go in there and do the work and get it done properly.
Sorry to be honest with you, I'd rather give him a refund. We don't get along, and that's all I'm going to say. There's no sense in me sitting here, he's called me a liar and everything else, sir. I'm not going to say anything else.
All right, so you're gonna give them a full refund?
No, I don't know if I want to give him a full refund, but I'll give him a refund.
No, we're gonna do either a full
All
refund or
right.
we're gonna do the work.
It was $2,500 and he'll get $2,500.
30.
That was for the total job.
Negative, sir. I have the contract in front of me. This was the amount that I.
Fine, I'll give him
the
3,500.
microphone, sir?
I don't care if he works for the sheriff's company or not. This is a little weasel.
Okay, no name calling in here, sir. No, it is, no, well.
I
that's
need you
not a
in the
weasel.
microphone, sir.
Okay. Are you content with the full refund, 3,500?
Yes, sir, I am.
Okay. All right, I'm gonna go ahead and rule on this case, okay? And my ruling in this case of ROWV 22028, that a full refund of $3,500 will be paid to the claimant within 5 days. And if 5 days is not paid, a fine of $500 a day. Okay?
Sir, I need 15 days.
Huh?
I need 15 days.
You have a problem with 15 days?
No, I agree.
No? All right, 15 days or a fine of $500 a day.
That's fine.
Okay, thank you.
May I say something else for the record on this one?
No, we're done. You're getting your $3,500 back.
Yes, sir.
You don't have to deal with. Okay, we're done.
Copy of the contract was $5,205.
Huh?
$5,205.
What's that?
The total contract.
I thought you said it was 3,500.
What I paid.
Oh, well, that's what you're gonna get back.
I understand, yes, sir. Yes,
Okay.
sir. He said the total contract, so again.
No, 3,500.
Thank you. So how do I, you said Casey pays it to the county and then the county,
No, he would pay it to you. It's,
I don't trust the check from him and bounce.
well, you're gonna have to put a little trust somewhere, okay? If it bounces, you let the county know, and he's gonna get $500 a day hit,
He already refused to pay his subcontractors.
huh?
He didn't pay his subcontractors.
That contractor, subcontractor, that's not even part of this equation.
I understand. I don't trust him.
Well,
That's,
you're gonna have to trust him one time, or he's gonna get hit with a $500 a day fine.
okay. And then I would just reach out to Mr. Carnero.
No. Excuse me. Can I talk?
I guess.
My name is Max Montel with Capital Program. I am Mr. Carnero's manager. This is a legal case. Mr. Carnero is an inspector. So I do not agree with Mr. Carnero be the point of contact, an agreement about money between two citizens. His job is performing inspections. I think that the right way to refund this guy is your honor, define a method that will be safe for the party involved on the layout to avoid a conflict. Since these two people are in conflict, I think the right way is define a method. But I do not agree with my subordinate being involved on that process. Thank you.
Okay. Is there anything else I need to do? I couldn't hear a lot what he said, so.
I can repeat it again if you need.
He just doesn't want, that Mr. Carnero is an inspector. He doesn't want him involved in any disputes with the money.
No.
That's a legal matter. He doesn't want that. He wants him out of that.
All the owner has to do, if he doesn't get paid within the 15 days.
No, he would let your inspector know that he didn't pay.
Okay.
And then he would send us an affidavit of noncompliance and we
Okay,
start a file.
perfect. We are.
Yeah,
I just
I,
want-
I agree with that too. That's mean, you just let me know if you when you receive the money
Yes, sir.
And then-
or not.
That works.
Yes, sir.
And then however that works, then if he doesn't pay you in 15 days, then the county's gonna get $500 a day,
Yes, sir.
okay?
Okay.
Just one question. That doesn't take care of the violation if he gets a refund.
No, you are correct.
No.
The driveway have to be redone completely.
Yes, in previous conversation, he told me that he was planning find the other person. So the property is gonna be still under violation because the work need to be complete. So after that, they need to apply for the permit and they need to start the process
Okay.
in order to remove the violation.
I think it's,
That is understood.
yep, okay, I think it's fair. Okay, thank you very much, sir.
Thank you.
Thank you for your
all of you.
service
Thank you.
to Hillsborough County.
I appreciate it, sir. Yes, thank you. Mr.
Thank you.
Carnero, thank you very much for facilitating.
Thank you, sir.
I will be glad to be done with that maniac. I can say maniac now.
And who's the
A
lady?
pleasure, sir. Thank you.
No.
Have a nice weekend.
Wait a little bit, wait a little bit.
Okay,
Wait until you are sure he is not here anymore, okay?
Make sure that he's not in the parking lot.
Yes, wait a little bit and then you go.
you got one more case, or?
No, just for the record, let's go back to page 11, number 23. Case number L217171. This case complied April 11, 2023. Number 24, case number L227385. This case was pulled per staff. And back on page 14, number 29, ROWV-23001. This case was pulled per staff, and that does conclude the agenda.
Good. Anybody have any questions?
No, thank you.
Everybody happy?
Yes.
Good. We are adjourned.
Thank you. Have a nice weekend.
heard it because you weren't in person there.
There's no back in the meeting.